Good afternoon. Thank you for joining us for our second Lunch and Learn in this series with Sarah Kay, Elise Elsberry, and later Rebecca Perra. My name is Megan Moschel, and I'm moderating this program today for the Alternative Dispute Resolution section, of which I am the chair of the CLE committee and member of the Executive Council. If you're not a member of the Alternative Dispute Resolution section, I encourage you to join our dynamic group. Our membership is comprised of mediators, arbitrators, and attorneys who participate in various forms of dispute resolution processes. The Alternative Dispute Resolution section offers valuable resources and networking opportunities with others who are leaders in the field of ADR. We also would like to thank our annual section sponsors, Miles Mediation and ADR Notable. As to housekeeping matters, so if you wish to ask questions of the speaker or need technical assistance, please utilize the chat feature. The presenter will answer all questions at the end of the program, though they may answer some questions throughout. You'll need to log into the Florida Bar Members Portal to enter your own CLE credit. Today, the first program that we have is going to be Child Support Simplified, Practical Tips for Mediation from Sarah Kay and Elise Elsberry. I'll announce the CLE numbers at the end. They'll also be posted later when it's on our YouTube channel. This program, the first program, counts for a 0.5 general CLE credit and 0.5 family for that certification area. At 12:30, we will have Rebecca Perra talking to us about improving outcomes for families through structured co-parenting communication. And that is for 0.5 general CLE and 0.5 family for that certification area. It's also going to count for 0.5 tech credit, which I'm excited about because I need some tech credit. And she'll go through our family wizard, the mobile and web app, some AI messaging calendar. So that's how you get your tech credit. This course is also going to qualify for CME credit, which does not require a course number because it's self-reporting for the purposes of renewal of mediator certification with the DRC. So you'll just have those program titles, and generally the CLE, CME count for about the same amount of credit. So I'd like to introduce our first set of speakers. I'm really excited to have them here today. I've been looking forward to this one. So we have Sarah Kay and Elise Elsberry. They are both Florida Supreme Court certified mediators who bring deep experience, clarity, and compassion to the families that they serve. Sarah is a board certified expert in marital and family law and a fellow of the AAML, leads K Family Law PLLC in Tampa, and is known for her work as a family and appellate mediator, collaborative attorney, consultant, and coach. Her leadership within the Florida Bar and statewide committees reflects her commitment to ethical practice, innovation, and strengthening the legal system for Florida's families. With advanced degrees in law, education, and business, and specialized training in neurodiversity, trauma, and conflict resolution, she approaches her work with warmth, insight, and a dedication to meaningful impact. Welcome, Sarah. And Elise Elsberry complements this with more than 2 decades of experience in public communication, governmental affairs, and conflict resolution. A Florida Supreme Court certified family dependency and circuit civil mediator, she draws on a strong foundation in broadcast journalism and public involvement to help parties feel heard, stay focused, and reach practical, durable solutions. Her background includes leading public information efforts for major infrastructure projects, navigating complex stakeholder dynamics, and serving on the Mediator Qualifications and Discipline Review Board. Together, Sarah and Elise embody professionalism, empathy, and shared commitment to helping families and communities move forward with clarity and confidence. So we are lucky to have them here today to talk to you about child support. Take it away, ladies.
All right, welcome and thanks for joining us for Child Support Simplified, practical tips for mediators, or as I like to call it, all things child support. I'm Elise Elsberry, a family mediator, and this came about because I felt like I was always asking questions about how to calculate child support or listening to people argue about whether something should or shouldn't be included in the calculations. One of the people that I was constantly reaching out to is Sarah Kay, a very respected attorney, mediator, and educator. Sarah's an expert in the family law arena, and together we're here to help you get the tools and confidence you need to calculate child support.
We are thrilled to be here today. Thank you so much for joining us. We've got 30 minutes to cover a lot of topics. We're going to be hitting a lot of things high level. We're going to go through some basics of child support, which include the kind of the fundamental concepts. Then we'll pivot into income, allowed deductions, miscellaneous things that very frequently come up when we're calculating child support. The Smith-Speed credit, because you will hear people talking about it, so we'll demystify it for you. Talk about the importance of the 20% overnight threshold, and then we'll wrap it up with the last word. And we did prepare about 30 pages worth of materials. So you'll hear us making references to the materials. If you have not yet received them, I'm sure that they're going to get distributed to you. And if for some freaky reason you don't have them by the end of this program, please reach out to us. Let us know. We're happy to share them because we wanted them to be a kind of quick hit resources for you. So when these types of questions come up, you have a place to go to find some potential answers. So let's start with income, Elise.
Yeah, several factors are important when calculating child support. The number of minor children, the number of overnights with each parent, and the income of each party and the allowable deductions. In addition to salary or wages, you need to remember to include bonuses, overtime, commission, tips, or other similar payments, workman's comp, Social Security benefits, and anything that would reduce their living expenses in regards to compensation for work. Now, guidelines are run on monthly incomes, so don't forget to double check how often they're getting paid. It makes a difference if they're getting paid twice a month versus every 2 weeks.
And the
Now,
one exception to this rule is when it's a non-reoccurring income, like if someone sold a house or sold a major asset, then that may very well not be included.
if you're running guidelines that include military income, you need to be aware that there's taxable income and non-taxable income that needs to be included. Taxable income includes base pay, cost of living adjustment pay, as well as hazardous duty pay and additional pay for services in a specified career field. Now, non-taxable income includes basic allowance for housing, as well as an overseas housing allowance and overseas cost of living allowance. VA disability pay should also be included in the non-taxable income category. Now, it's important to get the income into the correct column or classification because the goal is to determine the actual funds available to support the child. Deductions lower the total amount of income the court can use to determine a parent's obligation. If you have a situation where a party is unemployed or underemployed, you might be looking at imputing minimum wage, or you might be looking at the party's last 5 years of work history. Another way is to look at the income rate of similar work in their geographic location. You need to dive into the details if a party is looking to have no income or lower income due to a disability or being a full-time caregiver or student, because those are not automatic disqualifications from imputed income.
They're also not automatic qualifications for imputed income either. So they're going to be very fact-specific inquiries. For the median income, there is that section in the child support statute that talks about if someone has failed to participate in the proceedings, failed to give the necessary information for the child support calculation, they can get imputed at the median income. Oddly enough, the statute doesn't give really clear instructions on where to find that information. I have included in the materials the link to the U.S. Census Bureau where you can find a huge Excel spreadsheet with different industries and different geographic regions and gender breakdowns for median salaries. A lot of times that's where I'm going to be going to if people are looking for the median income calculation. We're going to pivot into allowable deductions. And the key word is allowable because I've lost count of the number of times I'm mediating cases and they're trying to deduct rent, they're trying to deduct, the grooming bill, they're trying to deduct everything from their income. And it's important to redirect them to the concept of the allowable deductions for those. Practice point for this, because we're going to talk a little bit about taxes, that taxes are allowable deduction. We live in a state where there is no income tax. I had a case not that long ago where one of the parties lived in California. So, of course, I'm running the guidelines and they're looking, they're going, where's my state tax? And I'm like, it didn't, wasn't on my radar right off the bat to make sure that I go in behind the scenes to make sure I'm including the state income tax. And that can be a major swing in the calculation. So when you are working with people that are living outside of the state of Florida, make sure that you're coding it properly in your software. Or there's also websites where you can go to do tax estimates if you're doing the manual calculations. All right. Child-related costs often come up. Now, the child's insurance premium is going to come off of the gross income calculation, but then excuse me, not the gross income. Certain child-related costs are going to come off of the gross income calculation, but then there's going to be the below the lines, the net income calculation, and the ones that come out net, the ones that appear kind of after the net income has already been determined, things like childcare are going to come off of the bottom, and those have a much bigger swing on the calculation itself. So pay close attention to where the child-related costs are getting deducted, making sure that you're inputting those properly into either the gross deduction or the net deduction. But the vast majority of them are going to be net deductions. The parent's insurance premium comes out of the gross deduction. The child support and spousal support is an allowable deduction. However, it's only the stuff that's actually getting paid. So I've talked to a fair number of people that are saying, well, I have a court order. I'm like, when was the last time you paid it? Well, about 3 years ago. Okay, let's talk about that. And let's figure out. And then the other thing is that it might be, well, I have some special support, but there's no court order. That's also going to have a conversation about whether or not that's actually being paid and how, if any, impact it's going to be having on there. All right, mandatory union dues and mandatory retirement. Again, this often comes up, people saying, well, I have my 401k contribution that I want to make sure is accurately reflected in the child support guidelines. Well, the statute only allows for mandatory deductions. So I often ask, are they really mandatory? Like, really? Like, are you going to get in trouble? Like, do you have any control over how much is getting deducted from your pay? Now, I'm originally from Massachusetts, so the whole union dues thing rings true to me because in my prior life, I was a teacher in a public school. We had legitimate mandatory union dues. I had no control. The minute I got my job, they were pulling those union dues out of my pay, and I had no control over that. You can try to opt out of the union dues, but then they charge you a surcharge for all the negotiations that the union does anyways. So typically you're going to be seeing those mandatory union dues with if there's some sort of government employee. Sometimes you get that with like the firefighters or the police unions, but oftentimes you'll see it with the people living up north where the unions are still very strong. Also with the retirement, generally it's going to be the government retirement that are mandatory and everything else is going to be discretionary, but it's going to have a conversation. It's worth a conversation about making sure they truly are mandatory. Right. Child-related expenses, you have the option one of two ways. One is including it as a pro rata or agreed upon percentage that's paid outside of the guidelines. The other one is including them in the actual guidelines. And this, it's funny because people are like, oh, look, I'm paying less child support. I'm like, no, you're not adding on the fact that you're going to be paying for the daycare separately. You know, that's still money out of your pocket. And having the conversations about whether or not the person who's going to be paying child support, if they have a history of non-payment, it may be worthwhile to include it in the guidelines calculation. But then for simplicity's sake, specifically with the cost of child care, where it fluctuates year to year, or out-of-pocket medical expenses, it may be simpler to be having them paid on a percentage basis separate from the guidelines. One way or another, they need to be addressed during the mediation, and asking the questions to help the parties explore all of the options is going to be key, the different pros and the cons to each of the approaches. So, Elise, what other considerations are there with child support?
Well, you'll have cases where there's Social Security payments. So if a child receives a benefit payment because the parent's disabled, the child's dependent benefits paid by Social Security must be credited toward the disabled parent's support obligations. And sometimes that's an equal swap, and sometimes it's not. Now, if you have a child that's disabled, then any benefit payments received from Social Security are not included in the calculations. If you have adult dependent children in your situation, they have their own unique consideration requirements, and they're governed by Florida Statute 61.1255. We are not covering those here. Just know that they are their own sticky wicket, and any support for an adult dependent child needs to be looked at carefully because it may impact any benefits from the government that they receive. The other thing that we're seeing a lot of is modification requests. Florida law recognizes that a change in circumstances of either parent may justify a modification of an existing support order. Modifications are based on significant and permanent changes in factors like the number of overnights each parent has, or permanent changes in a parent's income that would adjust the amount of child support by a minimum of 15% or $50. Now, you'll have cases where an increase in the basic guideline amount under child support guidelines over time may also qualify for a modification, even though time sharing or income hasn't significantly changed. So say support was calculated several years ago, even if the number of overnights with each parent doesn't change, calculating at today's cost to raise a kid could be enough to trigger a change if the difference between the old guideline amount and today's guideline amount is 15% or $50.
A lot
Now,
of times with those modifications, the people come in and start talking all sorts of things of all these things that change. And it's just a matter of math, doing the math to say, okay, well, if the math is going to influence the guidelines, then yeah, the court's most likely going to find it to be a substantial change. But if it's not impacting the guidelines by that much, what's the point?
right, because if both parents income has gone up significantly, it ends up kind of being a wash. Sometimes you'll have parties come in and they want to deviate from the amount in the child support guideline worksheet. Parties don't have to justify or explain a deviation of less than 5%. However, a bigger deviation must be allowable and explained in writing. So the allowable deviations can include things like special medical education or developmental needs of a child, if there's high travel costs due to a time-sharing arrangement, or in situations where a parent without sufficient income to maintain a housing or basic need. Those would be allowable deviations depending on the facts specific to that case. But just because somebody wants to deviate or waive the exchange of child support, it's not an automatic. It has to be by statute, and you know, it gets a little tricky when people start talking about the support and so on and so forth.
And people talking about waiving child support, that is a deviation. That's the technical term. Because the court cannot finalize the case without having a child support guidelines calculation on the record. And if the guidelines are, $500 a month, but the parties' agreement says that no one's paying any child support, then they need to be ready to go in and explain it. And it's worthwhile when, serving as the mediator, asking questions about the why and asking questions about trying to get behind the reasoning of it, and asking them how they see that as matching the statutory allowable deviation factors. Smith's speed credit comes up a lot. Really, this is essentially afterborn children, other children that are out there. I had a case not that long ago that I was representing the mother of a child. The child for the dad was number two. He had probably about seven kids by about four or five different women. And this child, who was child number two, had special needs, and the mother was looking for a modification of the child support guidelines. And we had to take into account the fact that this dad had probably about four different income deduction orders garnishing his wages. And this is where the Smith speed credit comes in, of trying to calculate the impact of those other court orders on the current child support guidelines calculation. There's in your materials, there are a whole bunch of cases, including the Smith case and the Speed case. These are named after two seminal cases addressing additional children in the child support guidelines calculation. I use family law software. I also know that it exists in some of the other softwares that calculate child support. But if you use family law software, there's actually a checkbox for Smith Speed Credit where you can check it and then put the information in. From the mediator's perspective, the long and the short of it is getting information about the child support orders for the other children, and or the estimated costs of payment for those other children, and making sure that they're included in the guidelines calculation in the appropriate spot. Now, it's not your job to figure out whether or not they need one or whatever. It's a matter of just asking the questions to make sure that the information is out there, and knowing where to put it once you get that information. So there's additional information in our materials. Encourage you to read through those cases. All the citations and summaries are in there to help you out.
And
What about
remember,
20? Oh, sorry.
I was just going to say, remember that the credits like Smith Speed or deductions are ordered and paid.
Mm.
So keep that in mind. Now, you're seeing less situations where a parent would have less than 20% of the overnights, but the reason that 20% is important is because it triggers what's called a gross up in the calculations. And what that does is take into account that both parents are maintaining significant separate homes for the child because they're having significant time sharing. But if you have a situation where you're right at the 72, 73 overnights for one parent, know that 73 is the magic number that equals 20% for the gross up. But if you're working off of the DOR worksheet, the Department of Revenue worksheet, or other software programs, sometimes you'll have a glitch if the number of overnights is right at that 20%. And so the way to check that is to run those numbers with a couple of additional overnights and run those numbers with a couple less overnights and see if where that lines up. But at 15% overnights should be a slightly higher child support payment than if you have 20% overnights. And you'll hear people say that the Department of Revenue worksheet has a glitch. Just keep an eye on that.
And at the end of the day, the judge has ultimate decision-making over authority over what is best for the children. The parties can agree to whatever they want to agree to at mediation, but the judge has an independent obligation to review the agreements and to make determination as to whether or not to approve those. There's plenty of case law, and we've included it in the materials to say, hey, listen, judge can't delegate what's best for the kid, whether it come, to the parent, to the child, to the therapist, to the guardian ad litem. The judge has the last word on what's best for the kids, and the judge has every right to take a look at a child support agreement and say, no, I'm not signing off on that. I know of a couple of magistrates in Hillsborough County and who would look at agreements and send them back to the parties and saying, I see that the guidelines say $500 and I see that you're only agreeing to $100 and there's no explanation. So we need to either set a hearing so I can take evidence to understand it, or you guys need to go back to the drawing board to have another conversation. So the judge has the ultimate decision-making authority when it comes to child support matters, all things kids, really. So with that, thank you. Please reach out to us. The QR codes that are on your screen will reach out to each of our contact information so you can contact us. Elise, okay, people reach out to you with questions?
By all means, yes. In the materials that you'll get from this, there is a quick tips sheet, which is kind of like almost like a checklist for you to make sure that you've included everything that needs to be included, or you've helped them have conversations around the issues that are going to come up for child support.
Thank you all so much. That was really helpful, especially for those of us that I know, probably most of us here are doing family law cases. And so that was really, really helpful. I appreciate it. We are uh, going to move on to our second speaker. I do see there was one thing in the chat about mentioning some materials and will they be sent after the webinar? I don't know if you guys want to put up your slide again of your information.
Oh,
Um,
yeah,
so
of
that they
course, I just
can
looked out of it.
reach out, yeah, for any materials,
And
unless you guys want to drop them in the chat. I'll
I
leave
will
that up
drop
to
them
you.
in the chat as well. So,
Perfect, perfect. So those materials will be in the chat. For anyone who is watching this on the recording, feel free to reach out to us at flabaradr@gmail.com and we'll make sure to get you in touch with the right people for materials. So I'm also, before we move on to Rebecca, I'm going to drop into the chat our link to register for our March Lunch and Learn. All right. So next up, we have Rebecca Perra, and she is going to talk to us about improving outcomes for families through structured co-parenting communication. Rebecca is a family law attorney as well as a family law and dependency mediator. She also serves as the judicial education coordinator for our Family Wizard. In this role, she educates judges, lawyers, and other family law professionals on the online tools that are used to reduce conflict and increase accountability in high conflict co-parenting situations, and she's going to show us all of that today in an abbreviated, I
Yes.
guess, manner. So take it away, Rebecca. Thank you so much.
Thank you so much, Megan. Hi everyone. Happy Friday. I'm so excited to be here. Thank you, Elise and Sarah. I really needed that. I needed that information. Yes, my name is Rebecca. I am so thrilled to be here. I myself am a mediator, and I absolutely love connecting and collaborating with other mediators. So it's truly an honor to be here. Thank you again, Megan. I put some materials in the chat. I put my email. And I put some items that I'll be referring to in my presentation. But without further ado, I'm going to get going because I got a lot to cover. So I am going to get going. Now, that being said, if I'm going to show you a lot, but I promise you, our Family Wizard is an easy app to use. It's very simple for parents. I just have a lot of material to cover, so please reach out anytime. Put in the chat if you have questions. If I don't see the questions, because sometimes I get moving, Megan, feel free to jump in or anyone jump, or I mean, in the chat. And then if I don't see it, just let me know.
Will do.
Thanks, Megan. Okay, so our Family Wizard, what is it? I'm going to give you a high level first. What it is, it's a co-parenting communication app. It's really designed to take co-parenting from 10 million spaces and put it in one space. So it has a calendar, it has a calls feature, it has a messaging feature, it has a journal feature, it has an info bank. So really, it takes co-parenting from 10 spaces and puts it in one space. Many people think of us, we've been around almost 22 years. People think of us, oh, you're that high conflict tool. And I'm like, that is, I mean, correct in a sense, yes. But truly, I present to collaborative groups quite a bit. I will always believe in my heart and soul that this needs to be a tool that will never see litigation because it is truly a fabulous organization tool. It has so even if you are mediating and there's two parents that are busy working professionals. My mother was a teacher. I did not know you were a teacher, Sarah. So that was a really cool fact. But my mom was a fifth grade teacher until the day she retired. She could not be on her phone. I mean, lawyers, mediators, we can't be looking on our phones all day. So it takes all the co-parenting things and puts it in one space. It is used by over 1 million parents. We are recommended by many professionals, ordered in all 50 states and across the world, actually. It really can save time and truly reduce conflict. And that's what I love talking to mediators about, is that, if our goal is to, in a sense, get an agreement, if the conflict and the heat can come down, sometimes the chances of getting that agreement can be greater. Okay, so I'm going to go through the tools. First, I'm going to go through how it would look in mediation. But first, why, again, the whys of On Our Family Wizard. We truly do believe we're a mission-driven company, and we do believe that better communication can ultimately mean better outcomes for the parents and ultimately any kiddos involved. We're actually, another fun fact, we're used a lot for pets. I did a whole article on using co-parenting apps for pets. So truly, think of it in any which way you want. I think it was for like a magazine in New York City. I don't remember what it was, but if you're interested, I would be happy to send it to you. Okay, so now let me go into just kind of the breakdown of Our Family Wizard in mediations, because I think many don't quite grasp why the mediators need to know about it, what they need to know, and how to implement it. So first, I'm going to touch kind of quickly, because you all probably know this, but communication breakdowns can happen, in a mediation. I am a very visual person, so I often visually can see the communication. Well, I can see their expression if I see it starting to go downhill. I think with communication breakdown, you can just see it unfolding before your eyes in most cases. I think tone, timing, and sometimes the absence of a shared organization tool can also magnify misunderstandings. That's why I do think it's important I love when parents are using this tool before they even see me as a mediator, because I really think, again, it puts it all in one place. It can reduce misunderstandings. I used to be a court mediator. We had 3 hours. That is no time to waste. No time. So, I mean, anything I can get to reduce the back and forth and the he said, she said is my friend. Um, so, moving from conflict to clarity, how it can help, how a co-parenting communication tool can help. I mean, I think, this could be its whole separate thing. And, Sarah does great presentations on trauma-informed courts and everything. So I'll defer to her on this. But I think being aware as mediators that parents could be coming in there could be a history of domestic violence. They could be holding some, I just think it's our duty to know of some certain trauma-informed considerations as they, get to us in mediation. The parents themselves can be entering mediation, carrying significant emotional weight, fear, frustration. There could be different power dynamics. We also have to be mindful of confidentiality boundaries. So I think as I go into the tools, please know that the OFW is a closed platform. So, but I don't want them to go into OFW and report, well, in mediation. I mean, I think to make it clear that what happens in mediation is mediation, and that does not cross into the co-parenting space, in the co-parenting communication tool space. I mean, as mediators, we have a duty to neutrality. And I mean, I think with neutrality, how that would look for technology. You present technology as a possible resource, not a directive. So the parties are always going to maintain their autonomy. I think that's a key component to maintaining neutrality, even if you think it could benefit them. And honestly, I think as courts can increasingly order co-parenting communication tools, we as mediators have a bit of a duty to at least, I mean, you don't need to be experts, but at least have a, basic understanding of how they're going to work and the tools that might be available for parents. So how are we going to, let's get past all that. Let's talk about how as mediators we could introduce co-parenting communication apps. I always use neutral phrasing. So some families use structured communication tools to help reduce conflict. Dot, dot, dot. One option some co-parents choose is a structured communication app. It can help keep schedules, messages, and expenses in one place, which often make it easier to stay focused on the children rather than any conflicts. Another wording I have used, sometimes families benefit from shifting communication into a more organized space. There are tools designed specifically for co-parenting that promote clarity and reduce stress. Always helpful to have brochures on hand if you do in-person mediations. I did put my email in the chat. Please email me if you would like e-brochures or physical pamphlets for your in-person mediations. Happy to send those your way. I do find an increased agreement rate because I think the structured tools can really, again, it takes out the he said, she said. It can lead, you're going to have, in my experience, fewer misunderstandings. So if there's we're going back and forth, and even the attorneys don't know. If I need to know whether a call happened per the parenting plan on a Wednesday night, and that's taking an hour of time, and I'm going back and forth and back and forth, that's a waste of the mediation time. Whereas if they come in and they've been on a co-parenting communication tool like our Family Wizard, all I have to do is look at the call reports. That's it. Did the call happen? Did it happen for the amount of time? Were there any funny business going on? Was the call muted for 14 of the 15 minutes? You have it right there. There's no guesswork and there's no back and forth. The records in our Family Wizard are unalterable. So I think when you talk about different, if there are, if there ever has been a safety or security concerns in a case, I think by keeping a concrete platform such as our Family Wizard, it can take away any gaslighting, any, if somebody's manipulating messages, any claims of that, you cannot do that in this platform. So now, let me keep going so I can show you the platform so you can get that tech credit. Use of data. I mean, so I think if they come to mediation, if they've been using a co-parenting communication platform, if they come to mediation, whether they're pro se or with their attorneys, and they bring in the reports from our Family Wizard, it really can reduce the he said, she said, and it can allow the mediation to focus on solutions rather than recalling battles. Like, oh, you did this, oh, they did that. I don't know. I'm the mediator. I'm not there. I always say, like, I'm not in a robe. You certainly don't want tax advice from me. I cannot make decisions. I am here to guide a discussion. So I think when they come in prepared with reports, it can really facilitate a streamlined discussion. They can, with these reports, them and their attorneys can also look at the patterns in communication and scheduling and how everything's been going. The data is neutral and uneditable. So it's going to provide a factual foundation. It can lower defensiveness and support more productive negotiations. Again, when I was in the courts and I had 3 hours, that is not a lot of time. I'm certain many on here are private, and I know how long those can go. But again, when you have 3 hours, you are in a time crunch. The importance of transparency. Everything is time-stamped and unalterable. And I think, organized reports can really streamline the discussions, which can help parents reach agreements more efficiently and with less emotional escalation. So with that, for me personally, I like things almost spoon-fed to me. I need things shown to me. So how would you ask for it? What's a way you could ask? Like, are you on a co-parenting platform? Could you bring any records with you? The way I've asked before for today's session, it is helpful if attorneys and self-represented parents bring any, in this case, I have our family wizard, but co-parenting communication reports, such as messaging, time or calendar, and expense summaries. These reports provide a clear timestamp record of communication logistics, which allows us to focus our time on problem solving rather than reconstructing past events. Having them available often makes mediation more efficient and helps us move quickly towards resolution. Or let's go much more simple. Please bring any applicable reports to mediation. These neutral timestamped records help streamline discussion, reduce misunderstandings, and support an efficient path to agreement. Okay, where people put this as a mediator, that is such a personal choice, and it's how you run your business. I am not going to tell you how to run your business, but where I have seen it is if there's a mediation intake letter that's sent to attorneys or pro se parties. This is the most common place, in my experience, to request documents such as this. If there were pre-mediation instructions or a what to bring sheet, some mediators will attach a short checklist outlining materials, and that's where you could put in, co-parenting communication reports. If an email, it could also just be a simple email for less formal settings. The mediator may include a brief line in the logistical reminder email. Please bring any relevant, in this case, our family wizard / co-parenting communication reports to assist in streamlining discussion. That's it. Equitable access for all, regardless of income. We are always available to anyone, regardless of income. We have a fee waiver plan that is available for anyone working with a pro bono reduced fee attorney, pro bono reduced fee guardian ad litem or PC, receiving public assistance, deemed indigent by the court or clerk, or having survivors of DV are always entitled to free accounts. We are very widely available. We also have a military discount program where current and former military would receive a free account. So we have ample tools so that everybody would have access, not just people with financial means. Okay, so let's get into it. We got to get to the tech credit, right? Okay, so that was a lot of information, but here we go. So this slide shows our features, really. When I, am talking to parents, I often describe it as a co-parenting communication, like ecosystem. Well, maybe not, like its own little sphere, because again, it takes co-parenting from 10 million spaces and can put it in one. So if the people coming to mediation, again, surgeon, teacher, doctor, lawyer, nurse, anyone, they can't be looking at their phone all day. If they use our family wizard, they can set their notification alerts. They can set it so they get a summary at the end of the day. They can set it so they get notified every time. Doesn't much matter, but it takes it from 20 spaces and it puts it in one happy little space, which can be just a game changer. Okay, so let's get into, we do have, and everything I should say, our whole platform, app, platform, everything, and our customer support is available in both Spanish and English. They can download anyone is, the mobile app in Spanish. They can use our website in Spanish. I mean, whatever they need, they can use it. Whatever I show you is also available in Spanish. Okay, so, and if anybody on here, if they would like Spanish resources, I put a model order language, which I use most frequently to cut and paste in my parenting plans. It's in Word format. Feel free to cut and paste it as you see fit. It basically takes the features. If you are listening to this presentation and you're like, oh, I really like that one. I'd like these parents, that would probably be good for them. So if you chat with the parents, they agree it could be good for them, cut and paste it as you see fit. Anything I have put in the chat, as well as additional materials, I can send to you. We have Spanish versions as well. So if you do a practice that is bilingual, just let me know and I can send that out. And again, I will repeat, if you want pamphlets or materials, just let me know and I'll get those sent to you. My email is in the chat. Okay, so the calls. The calls are going to look very similar to a FaceTime, and that is quite intentional. But unlike FaceTime, it's going to keep very detailed reports. So, oftentimes in my parenting plans, there's a midweek call if it's a week on, week off type situation. Generally, there's a midweek call. I love these reports because they can show, did the call happen? And what happened during it. Because the reports will show, okay, the call happened Wednesday night for 15 minutes. But geez, that's weird. It was muted for 14 of the minutes. It kind of gives you the insight into did it happen and what happened. But again, it's going to look very similar to a FaceTime. It's very simple for them to use. We are very, very mindful of parents and anyone who uses it, privacy. We are always supportive and protective of any survivors of domestic violence. So we have the highest level of privacy and security. There's always going to be consent with our calls, so they would have to consent to both the audio and the video. We have two versions of our calls. We have unrecorded and we have recorded. This is for the unrecorded. They would have to consent each and every time because, again, if there's a domestic violence survivor, they're in a shelter, they cannot be on video. So they would consent to audio only. So the consent would have to happen every time. Anybody on here, if you do dependency, this is really taking off in the dependency space. Why? Because they don't need to share any details. So if you have an emergency caregiver, a foster parent, all calls are placed through the app, so no phone numbers need to be exchanged. Just email me. I can talk to you more about it. But yes, it's really taking off in that space because there's no identifying details by using the app. They don't have to exchange phone numbers. It is placed through the app, not their phone numbers. Okay, so let me keep on keeping on. Call recordings and transcripts. The second version of our calls are the recorded calls. That consent is going to look a little different. As you saw with the last consent for the unrecorded calls, that will be a toggle. This will be more, specific. By continuing to be in this call, you are consenting to be recorded. If you include your child on the call, you are consenting to them being recorded. I think this is a fabulous tool, especially if there are any allegations or concerns with DV, safety, or security. I do think this can be a good tool. This is often a tool used when there's a guardian ad litem or parenting coordinator, because oftentimes they'll want to go back and watch the communication. So just a little note. Two-party consent is always required. I do my job a lot of places. I live in Florida, but I do my job throughout the Southeast and even nationally. So I, present a lot in places that are one-party consent state. Doesn't matter. There will always need to be consent on both ends, always. This feature, we are used a great deal because of our high levels of security. We are used a great deal in the military. And again, this is available also internationally as well. So there is that. Okay, so, it can keep parents on track. Again, doing my example of if they're coming back to mediation, it's post-judgment, and they are disagreeing that the weekly call is happening. If you have these reports in front of you, if the attorneys bring these or the pro se parties, it is super easy to get to the bottom of that. The reports can be right there and you can see, okay, call happened. The recordings, transcripts, again, probably wouldn't come up as much in your world. unless, again, if you're on here, maybe if there was a dependency case or if there were some DV allegations, but I do like you all knowing it exists. So, okay. And I will have QR codes, so if you need any additional information, feel free to scan it and check back on your own. Um, with basically all our feature, there's going to be reports. And this is where I think if these come into mediation, it will be your friend because it really can take back so much of the back and forth because you can really get to the heart of what you're trying to get at. Because again, in my experience, so much time can be they did this, they didn't do this, or they didn't see that message. You said the message, like so, it just can take a lot of time. And, that's okay. But again, I think having these reports is just incredibly helpful. Because again, just using an example of a call report, you can see that the call happened, how long it took place for, 5 minutes, 13 seconds. Did they turn off their camera? Did they mute? So there's all sorts of details. Now, the messages are always going to be time-stamped. It's always going to show if something's viewed, sent, received. So again, just using that example, they're coming post-judgment or, whatever it might be. And they're saying, oh, the parent never reads my messages. It's a terrible situation. You can easily, if they're using our family wizard, have them bring it. Look, maybe the reports do say they're never reading it. I don't know. But I think having these reports in front of you is just super helpful. The messages cannot be edited or deleted, so keeps it concrete. And so again, going back to those different like trauma factors and different items that we might encounter as mediators, whether it's domestic violence, in dependency, you can get significant substance abuse, also different situations. And I think the fact that the messages cannot be edited or deleted is super important and can be a really important tool. I presented to a DV org yesterday. They were in Massachusetts. It was on Zoom, but it was, and I say this to basically all the DV orgs I work with. I know there's tools out there, but I truly do think this is the kind of bar standard if there's any safety or security concerns. So it really can provide a safe space for communication. Message history reports, they're available as well. Tone meter AI. Okay, so what is it and what was it addressing? So tone meter AI, what parents were doing, and well-intentioned, I must say, they were taking messages from our family wizard and plugging them into ChatGPT. They were asking ChatGPT, clean up my message, and then they were putting it back in our family wizard. I think we can all say good intentions, excellent intentions. But ChatGPT is very much an open AI system. Our system is not. We said, okay, that's great, but here's the problem. We pride ourselves on security and privacy. Open AI is not it. So we have a very smart AI engineer. If I have time, I can load the article into the chat. But the article is from our AI engineer, and he talks about how he developed it, how it learns from itself. What it is a closed AI tool. It lives within the Our Family Wizard platform only. That's it. It is self-trained. It is just for co-parenting communication. It is not intended to draft code or I don't know. It is literally a closed AI system. They do not have to use it. That is very important to know. We do not censor parents. Never going to happen. But what it can do, well, what it does do in real time, it would flag any language that could be deemed negative. And then after that, if they clicked on the suggestion, it would generate a more productive message. It can keep the messages more clear, more calm, and it can reduce the conflict and stress. That's why I present a lot to collaborative groups because, I think as mediators and even collaboratively trained attorneys and mediators and whatever, our goal is to get a positive help, a good outcome. And I don't see a bad part of parties using tone meter AI. It can really help lead to better outcomes for these families because better communication is everything. I mean, really, it's everything. So this tool is available even if it was a free plan. So, okay. Let me keep on keeping on. So that is Tone Meter AI. If you have any questions, if I don't have time to load the article in chat, please email me. I'm happy to send it to you. Our calendar, we have color coded it for ease of use. We even, oh, here's a little fun fact. Color coding is by parent selection. So parent A picks their colors, parent B picks their colors. So if they print out copies and they're coming to mediation and one parent has red and green, one parent has purple and orange, that's okay. Nothing is wrong. We try to remove anything that could cause a fight, anything, because we want the better outcomes for these families. So each parent picks their own colors, whatever they desire. They do not pick each other's colors. So it's always going to be color coded. The way, let me go to that. We do have the more common parenting rotations that they can plug and play, but they don't have to. They can also customize it. Ooh, boy, I'm running low on time, so I'm going to keep going. Events are going to be color coded by pickup and drop off time. There is always going to be a clear record of when an event was created and edited. I have had this come up where in mediation they're going back and forth. Well, okay, they put it on our Google Cal, but it went on 5 minutes before. I don't know. But I think, again, when you have clear records coming from a co-parenting communication platform such as our Family Wizard, you're always going to get a concrete record of when it was created and by whom. So this one was created. There it is. Maybe it was 5 minutes before it happened. I don't know. But again, you're going to have that clear record. Within the calendar, we have a scheduled change request feature. What that is most people refer to it as the right of first refusal tool. Because that's really what it is. If they're supposed to be doing a right of first refusal, this is a great tracking tool. So if they come back post-judgment, these could be extremely good, helpful reports if that is an item up for discussion. What it is, it's intended to make small changes on their own to their parenting time without relitigating, remediating, any of that. They can send a little small request to trade or swap parenting time. The other parent can approve it, decline it, or make an alternate offer. If they approve it, it's going straight on. The reports. I love these reports. I think they're very telling because they can show if parties have been working together nicely. If you as the mediator are looking at a page or the attorney is looking, if you're looking at 20 refusals, maybe they could be working together better. If you're looking at one approval, because again, as they're going to separate, especially if you have parents in mediation, that one parent is starting a new job, they're going to very likely have very different schedules. And it's so important to have flexibility. Their life is not going to be the same as when they were together. So I think flexibility is crucial, really. So I find this report probably the most telling. Coming soon, very excited. I would say over the next month, calendar imports. It's going to import from Google, TeamSnap. As it stands now, they could export to a Google Cal, but we're going to do imports. So it's going to go right on Our Family Wizard calendar. It's going to default to private, at which time they could share it with the other parent. So again, when I say it takes co-parenting from 10 spaces and 10 million, puts it in one, especially if you have kids, you see Team Snap, you probably cringe a little like, oh, Team Snap. Parents get a lot of notifications. Journal, 2 parts to this, and then I probably got to wrap up. But I do love this tool, Moments. There's moments and there's check-ins. This is a very popular feature in the dependency cases because it can be a safe space to load a picture, a photo, if you have an ongoing, like a TPR type situation, but they want to exchange photos. They don't need to be on Facebook. They don't need to be on Instagram. They can load them here. We scrub the metadata and the photos get loaded. There are no identifying factors, which is part of the reason we are just wildly popular in the military. Because if somebody's in a super secret location, there are no identifying factors as to their super secret location. Check-ins going to function different. They can put a pin in their location, but our app doesn't follow them, so they'd have to enable location sharing. There is that. They would have to basically give permission. It would put a pin in it, default off. Little mediator tip, if in your parenting plans, you have, because this happened, kind of frequently, they want to know when another parent lands or takes off or is at an airport. This is a fun little tool because they can just basically just put a pin in the app and there it goes. So they know parent landed, TPA, or wherever they might be. Oh, goodness. There's reports. There's info banks, which stores all the children's things. So again, if you have a case, maybe one parent was not as involved as the other, they can load pant size, shoe size, belt size. Again, dependency cases, you have an emergency care situation, you need diaper size, all that jazz. So I'm going to keep going because I got to get to, they can pay each other, track expenses. Um, Professional access, we do have. Some mediators have it, mostly attorneys, guardian ad litems. But I do like saying, professional access is always free. Our security, our privacy is next level. Everything is encrypted, both when it is moving back and forth in the servers and when it is stored itself in the server. It is very well secured. Model order, I put in the chat. Oh goodness, I gotta go, Megan. So there you go. There's our customer support, and there am I. There
You
I
are
am.
great, Rebecca. I know we
Woo!
had to we had so little time for all that you had to show us.
Got it.
My brain was working on how some of these things that features you have could be adapted for even guardianship mediations.
Mm-hmm. Yes,
But I did have one question for
of
you
course.
on, you said that, there is that professional access.
Mm-hmm.
As mediators, is it a good idea for part of our intake to say, hey, do you want to give me professional access to Our Family Wizard so that I can take a look at what's been happening prior to mediation?
That's a great idea, Megan. It is used somewhat frequently that way because it's really up to the mediator, though. I mean, this kind of just goes to all our styles too,
Sure.
right? Some people want the printouts. So they'll say, hey, bring all the messaging. Me personally, I don't want the printouts. So yes, I think that's a great idea. And professional access is always free. Anybody can email me to set that up for them. Happy to do it.
Awesome.
Yeah.
Well, thank you. Thank you all.
Thank
Sarah, Elise, Rebecca, you all have been fabulous. And thank you for your excellent presentations and to all of you for participating in this Lunch and Learn today provided by the Alternative Dispute Resolution section. I'm going to go through the titles and our CLE numbers real slow so that I can make sure that everyone gets it. So the first program we had today was Child Support Simplified, Practical Tips for Mediation. So that title is going to be needed for self-reporting to your CME to the DRC. So again, that was Child Support Simplified, Practical Tips for Mediation. And that CLE number is 2517050N. I'll repeat it. 2517050N. And that was the program provided from Sarah and Elise. And then the second program that we just finished with Rebecca, that was improving outcomes for families through structured co-parenting communication. So improving outcomes for families through structured co-parenting communication. And that CLE number is 2517049N. I'll say it again, 2517049N. If you have any questions about those, if you lose it along the way, feel free to reach out to flabaradr@gmail.com. We hope you found this program insightful and we welcome your feedback. Again, feel free to reach out to us if you have any suggestions for future programming. Coming up on March 4th, we have the mediator complaint and disciplinary process. That is with Tad David of the DRC. On March 18th, we have our big full day Arbitration Advocacy Institute. So that is going to be a really great one-day program helping litigators be more effective advocates at arbitration. So if you know anyone who participates in arbitration, please share that with them, or please look into it for yourselves. And then April 2nd, we have a personal passion project of mine. We have Justice on the Spectrum, Neurodivergence in Mediation and Law, and it's scheduled for World Autism Awareness Day. We've got a great panel there to talk about working with parties who are on the spectrum, working with attorneys who are on the spectrum, and how we can make the process more seamless for everybody. We also have our mediator forums the first Friday of every month at 8 a.m., our arbitration forums the second Tuesday of every month at 8 a.m. And I previously dropped in the chat the registration for our next Lunch and Learn on March 13th. We're going to finish out this series on the second Friday of every month through July of this year. So we've still got some more programming to go. We will announce those on our social media channels. So follow us. We hope you will join us. If anyone needs, I see they're dropping the program titles in the chat again. I will mention them just one more time because I know I tend to talk fast. So we've got Child Support Simplified, Practical Tips for Mediation. That was from Sarah Kay and Elise Elsberry. It was 2517050N. And the second one was our program from Rebecca Perra, Improving Outcomes for Families Through Structured Co-Parenting Communication. It was 2517049N. So again, thank you all for being here today. We appreciate your attendance. We invite you to join the ADR section to receive access to more quality CLE courses and the latest news on dispute resolution processes. I realize we have some people here who are non-attorneys and may want to still be a part of some of the section activities. Feel free. Our mediator forums are open to everyone. Our arbitration forums are open to everyone. And Rebecca beat me to it. That was the last thing I was going to say. Our wonderful treasurer is on today, and I wanted to. You saw the slides in the beginning. For our annual section sponsors, none of this would be possible without them. So to close it out today, I want to say thank you to our annual section sponsors, Miles Mediation and ADR Notable. Thank you all for being here today, and I hope you have a great one.